When he was a prosecutor, I imagine he was deadly. He was obviously honest, decent, and fair. He came across to a jury terribly well. I imagine that the way things work, he may have got off a few people who probably shouldn't have been got off.
For the first time ever, that courtroom broke into applause. I'd never heard it before. I don't think I'll hear it again. And it just went on and on and on. And I said to him, Igor, stand here a moment and just listen.
And this is what Igor had said. Ultimately, it is the judges who are the guardians of the rule of law. They have a particular responsibility to protect the constitutional rights of each citizen, as well as the integrity of the Constitution, by which those rights exist. Without judicial independence and without respect for judicial independence, these elementary facts of our civilised community are threatened. That carried everything.
This is The Judges, Power, Politics and the People, hosted by the University of Law. Lord Judge was Lord Chief Justice of England and Wales from 2008 to 2013. He took up office after a decade of constitutional reform and upheaval under Tony Blair, which saw the Lord Chief Justice become head of the judiciary in place of the Lord Chancellor. It therefore fell to Igor Judge to restore judicial morale and oversee the reforms, leading the judges in fighting their corner with ministers and maintaining the judiciary's independence. He did it all with consummate skill and diplomacy. And when his time as Lord Chief Justice ended, in the words of Lord Neuberger of Abbotsbury, the judiciary's reputation was enhanced and its independence respected. Igor Judge was born in Malta. With his surname and his mother's maiden name, Micallef, meaning judge in Arabic, he had little choice, he would say, in selecting his profession. He went to the oratory school in Woodcote, Oxfordshire, where he was captain of school and, perhaps as important to him, captain of cricket. To Magdalen College, Cambridge, and then to the bar, becoming a member of Middle Temple, for which he maintained a fierce love and affection. In 1963, he joined chambers at 2 Crown Office Row, a powerful Midland circuit set, now 7BR, modestly describing his time there as a Midland circuit hack. In fact, he was a powerful jury advocate, combining charm, knowledge, and a great understanding of people. He became a High Court judge in 1988 and was promoted to the Court of Appeal in 1996. 4 years later, he was appointed Senior Presiding Judge and in 2005, President of the Queen's Bench Division. 3 years after that, he became Lord Chief Justice. As well as his judgments, Lord Judge gave many key speeches and lectures. 35 of them were published in a book shortly after he retired entitled The Safest Shield. On retiring as Chief Justice, he went on to become a leading figure in the House of Lords, highly influential and respected as a legislator. Very sadly, Lord Judge died last November, just a few days before he was due to be interviewed for this podcast. So this episode is a tribute to his contribution to the law and justice system by some of those who knew him best. I began by speaking with Lord Neuberger, who for 3 years as Master of the Rolls was Lord Judge's number 2 in the judicial hierarchy. They also worked alongside one another when Lord Neuberger became President of the Supreme Court in 2012. You knew Igor Judge for many years and you worked alongside him. You probably didn't know him in his early life as a judge, but what was his reputation, firstly as an advocate and then as a judge?
His reputation as an advocate, which I had to make inquiries about, was, as one would expect, almost mesmeric with the jury. He was brilliant, and as one barrister, indeed a future judge, John Goldring, described it, it was when he addressed a jury, it was as if he was sitting in the jury box chatting with them and talking to them. And he could just put himself in the position of ordinary people. And I imagine he made the most frightful criminals when he was defending them sound pretty reasonable and sensible, because he had this brilliant ability to make everything seem reasonable and fair. And because he was so obviously honest, decent, and fair, and he came across to a jury terribly well. And I imagine that the way things work, he may have got off a few people who probably shouldn't have been got off. That's the way the system worked.
When he was defending.
When he was a prosecutor, I imagine he was deadly, because the best prosecutors, both in terms of what is, in my view, required of them and in order to be effective with a jury, are always sweetly reasonable. If you're full of indignation about a defendant, I think it's counterproductive. And Igor would never be like that. He'd always be measured. Measured and reasonable. And the jury would get it because he spoke their language.
Yes.
He was the opposite of a pompous lawyer.
So he really was ideally suited to being a judge, wasn't he?
He was ideally suited to be a judge, because underneath that charm, underneath that reasonableness, he was a very, very firm believer in certain things and was quite uncompromising at times about certain things. And principles like honesty, independence of the judiciary, and patriotism.
You, I think, first knew him probably when he was in the Court of Appeal, is that right?
You're quite right. I really only got to know him when I was a junior member of the Court of Appeal. And he was, I think he was president of the Queen's Bench Division. He may have just been a Lord Justice, actually, in 2004.
And what was he like to sit with?
Well, he was not always presiding, because the presiding member of the Court of Appeal, there are 3 people in the Court of Appeal, and the presiding member is the most senior. He wasn't always the most senior, but he was, I was always the most junior. But he was just always friendly, unpompous. He'd done the homework, he had a view. And while he was firm in his views about things, he was always open to argument. And we would discuss cases before the hearing, and I'd sit in court with him.
He would change his mind when he listened to arguments.
He would change his mind. He respected the whole way the system worked. And while he had certain things he was very firm about, he was open to argument, open to persuasion.
He always seemed to me quite a modest man. He wasn't a show-off, was he? And he wasn't a sort of pompous judge in any way.
No, I think he was very self-confident in the sense that he was confident that he was able. He wasn't arrogant, but he was confident in his own abilities and didn't need to throw his weight around. He was just quietly authoritative in court. He would sit there and listen, and he just somehow, like a good school teacher, would give out the impression which was such that the advocates just wanted to do well in front of him and impress him. And he didn't do that by bullying them or shouting at them or throwing his weight around.
When you gave the eulogy at his memorial service, Thanksgiving service, you quoted, it came from him when he wrote a guide for judges when he was involved with the Judicial College. And he said, that the essential judicial qualities were patience, fortitude, determination, and the courage to do what you believe to be right, while recognising that as a human being you're bound to be fallible, but as a judge you are required to provide an answer rather than leave the parties in uncertainty. Because I imagine that a lot of people are not suited to being a judge because they find it difficult to be certain, to make a decision.
I think there are 2 extremes of people who are not fit to be judges. Those who think the answer's plain from the beginning and just don't listen to anybody or any argument as to why they might be wrong. And those who find it extremely difficult to make their mind up because they do see that it's in many cases that come to court. That's why they come to court. There are 2 sides to a question, and there are arguments in favour of each side. And neither party can meet all the points made by the other side. And you have to carry out a balancing exercise and decide whose argument is stronger. And some people are frightened of getting it wrong. And that's a sort of admirable modesty in a sense, but it's not good for a judge.
Then in 2008, the job came up of Lord Chief Justice, and he actually applied, didn't he?
Yes.
But he was really the obvious candidate. I think you've said that there wasn't going to be anybody else who stood against him.
In 2008, there wasn't an obvious candidate, and he was the obvious candidate. Sorry, there
There
wasn't an
wasn't
obvious
another one.
candidate apart from him.
Exactly.
And he was the obvious candidate. And the committee, which was chaired by Lord Bingham, to select who was then the president of the senior law lord still, now the president of the Supreme Court, the committee he chaired had to select the new Lord Chief Justice. And I think Lord Bingham said, well, there's only one candidate and he's the obvious candidate, so we should just select him. And one or two members of the committee said, shouldn't we at least have him along to see what he looks like? And he came along and, of course, acquitted himself extremely well and was duly appointed.
What do you think, in looking at his time then as Lord Chief Justice, and during that time, I think you served alongside him for 3 years as Master of the Rolls.
I was, in effect, his number two.
You were, in fact, his number two. What were his main achievements?
I think it's a sort of achievement that can be easily underrated, particularly in as time passes. The judiciary had been through a very wobbly period. And what he did was to ensure that they settled down very quickly and very well. And the morale, which had been seriously undermined, was strongly reinstated. There were a number of features over the past few years which had undermined the judiciary. One of them was the constitutional changes, which included a change in the way in which judges were selected for appointment and promotion. Originally, it had been by what so-called tapping on the shoulder. You were approached by the Lord Chancellor to become a High Court judge, and you were virtually told when it was decided you'd go to when or if you'd go to the Court of Appeal. And that's what happened to me. But they changed it to modernise it so that you had to apply. And instead of the Lord Chancellor deciding, it was a committee with lay people on as well as judges. That did, like lots of changes, have a seriously undermining effect for lots of people who wanted to apply, who wanted to become judges, but didn't want the, as it was seen, humiliation of having to apply and possibly get rejected.
So did he manage to somehow sell this, which he had no choice over, of course? I mean,
He
that
had
was
no
what it was
choice.
going to be.
It had been introduced already, and he was very good at getting the message across that people shouldn't be frightened.
He was very good at bolstering the rank and
He
file.
was very good at improving morale. And there were other factors. Pay had been frozen in a way which was unattractively done, and it could have been done in a much more effective way by the government. Pensions were being interfered with, and one of the great financial attractions of becoming a judge, because you take a very substantial pay cut in most cases, was the pension.
He was very, very strong, always, wasn't he, on the need for an independent judiciary?
Oh, yes.
The rule of law. These were his touchstones.
That was absolutely fundamental to his view of life on the constitutional front.
So he was a very good person to have as the head of the judiciary, standing up against ministers, had that been necessary.
Yes, I think he saw his role as being more important than it had been because of the removal of the old-style Lord Chancellor and his replacement by, unfortunately, a politician who was often on the make and often knew nothing about the law. I mean, for much of his time, the Lord Chancellor was Jack Straw, who was actually quite good. But he was followed by Ken Clarke, who was popular and Igor knew, but who, unfortunately, was very much at the end of his career and didn't do much. And then we had Chris Grayling, who was a disaster. And Igor did stand up to them and do his best.
And his dealings with senior officials, ministers and Treasury people, if indeed he had to deal with this, what was he like dealing with all these members of government?
He was very persuasive, very, very good. Even if he felt passionately and felt they were completely wrong, he didn't get hysterical or emotional or aggressive. He had this ability when he disagreed with you, or you disagreed with him, of if you listened to the conversation and didn't hear the words, he would sound as if he was agreeing with you. It was very elegant, but I don't know how he achieved this. But as a result it was never unfriendly. It was never, you never felt that you were fighting.
I think you put it very well, that he could disagree without being confrontational.
Yes. One of the changes he didn't like was the creation of the President of the Supreme Court, because that immediately undermined the authority, as he saw it, of the Lord Chief Justice. Because in the old system, the law lords were effectively out of the picture, and the senior law lord was a sort of vague figure who didn't really feature other than in the law, but not in the judicial hierarchy. But when they introduced the Supreme Court, they had to have an order of precedence for the President of the Supreme Court, because that was now a formal position. And inevitably, he had to rank ahead of the Lord Chief Justice, because he's higher up the hierarchy. And Igor felt quite strongly that that risked undermining the authority of the Lord Chief Justice.
Did he, I mean, it's too late to do anything about it because it was as part of the package of reforms, but did he ever make his views clear on it?
No, because it was
nothing
inevitable.
To be done.
Not merely nothing to be done, but if you think about it, the President of the Supreme Court has to have priority over the Lord Chief Justice, because you just look at the judicial hierarchy. And I think John Thomas, who did the negotiation on this sort of thing, who was Igor's number 2 in terms of the Queen's Bench division and so on. And at the time when Igor, before I became Master of the Rolls, I think, John Thomas saw that. There was just nothing you could do about it. Once you accepted that the President of the Supreme Court had a formal position, unlike the senior law lord, he had to rank ahead of the Lord Chief Justice.
Interesting.
But by contrast, as Chris Stevens, the chair of the Judicial Appointments Commission at the time, said to me, he said, "David, you have a cricket team and Igor has an army." Yes. And it's true. I just had 11 judges.
Quite.
I was, as it were, responsible for.
Yes.
Whereas Igor had the High Court, the Court of Appeal, the Circuit, the magistrates, the tribunals.
The entire judiciary.
Well, the entire judiciary of England and Wales.
Yes, quite.
And the tribunal judiciary.
Yes.
So it was a much bigger job than the President of the Supreme Court. And you can understand his feeling. In fact,
I think more influential, even if it was lower in hierarchy.
Oh, much more influential, absolutely.
Yes.
You could argue that the President of the Supreme Court was more influential in terms of the development of the law, and the Master of the Rolls, in a way, was as influential, if not more so, than the Lord Chief Justice, because they did more significant cases. But in terms of the judiciary and its role in the Constitution, the Lord Chief Justice was far more important than the President of the Supreme Court. And with Igor and then with John Thomas, when I was President of the Supreme Court, we worked quite closely together, and I regarded my role as being supportive of the Lord Chief Justice, because he had a much more difficult job than I did, and it was the role to support them. I think Igor wanted me to be President of the Supreme Court because he'd indoctrinated me by the time with this sort of thought. That he knew that there'd be no question of my trying to eclipse him, and on the contrary, I would want to try and support him. And I think that tradition with Brenda Hale and Robert Reid has continued.
So looking finally then at his career as Lord Chief Justice, his main achievements, would you say they were more to do with the reputation and standing of the judiciary than actual individual judgments that he gave?
I think he would certainly see it that way. I think he always thought, and with some justification, that his academic and legal abilities were generally underrated. Because he was such a reasonable, sensible man, he was, and because he'd never pretended to be particularly intellectual, I think that he saw himself slightly as the victim of his own qualities, or victim of his own PR, if you like,
yes,
and underrated as a lawyer. And I think there was some force in that. I think he was a good deal more academic and grounded in legal history and legal principle than people realised. And his presidency of the Selden Society and his subsequent essays show the depth of his love and knowledge of legal history and constitutional history.
And it certainly came to the fore, because when he finally retired from the Lord Chief Justice job, he had a second career, really, didn't he, in the Lords?
he moved seamlessly into the House of Lords and quickly established authority there, it seemed to me, which was exemplified by his election as a convener of the crossbenchers, a role he performed with his usual ability.
Yes, he was very active there. He spoke on a number of issues, but what would you think were the principles that chiefly guided him in the Lords when he was looking at legislation?
There's no doubt that the principles that guided him were constitutional propriety, and one of his serious concerns, which was absolutely justified and remains unfortunately justified, was the way in which governments used secondary legislation. Primary legislation being statutes which lay down the law, which are normally carefully considered by Parliament and carefully voted on and considered section by section. Statutory instruments are secondary legislation which are considered by government departments and laid before the House of Commons and House of Lords, which means they are there for consideration, but normally they get no consideration. Secondary legislation should be used for detailed procedures. For instance, if you've got an act governing planning permission, a statute governing how planning permission should be granted and obtained and the principles applicable, you'd have a statutory instrument that sets out precisely how you apply for planning permission, who has to be given notice, how much notice is given, etc. In other words, it's nuts and bolts stuff. But over the past 50, 60, 70 years, secondary legislation has been used for quite serious law changes, which have not been properly considered by Parliament.
So
the worst form of that are so-called Henry VIII clauses, which are sections in statutes which effectively say this statute can be changed by secondary legislation. So what it means is that the government, in the sense of ministers, can actually change a statute that's been made by Parliament, and they can do that through secondary legislation. And Igor rightly thought this was a peculiarly inappropriate thing to happen.
That became a new battleground for him. Well, he made a huge contribution, both.
He spoke about it a lot, and he spoke about secondary legislation a lot, and I think that was a typical issue. It's a sort of issue which 99% of the population have no interest in, and probably not many more than 1% fully understand.
But important
and yet it is
for the balance
very
of
important.
powers.
It is very important.
And how will you remember him then, finally, yourself?
Quite emotional, really. I remember him and Judith because it was a quite extraordinarily happy marriage, and she is a remarkable woman, just as he was a remarkable man. I shall also remember sitting with him in his room discussing legal issues that have come up for us to have to consider, constitutional issues, and also then him discussing aspects of English history, because I'm quite interested in English history, quite knowledgeable about English history. But unlike Igor, I don't have his depth of knowledge, particularly of the 16th and 17th centuries. And I love talking to him about that.
Dame Anne Rafferty served as a member of the Court of Appeal from 2011 to 2020, sitting with Lord Judge on some key appeals. She read law at Sheffield University, where she later became its Chancellor. She was the first woman to chair the Criminal Bar Association and the only barrister member of the 1991 Royal Commission on Criminal Justice, chaired by Lord Runciman. Like Lord Judge, her legal career was carved in the criminal courts. I asked her what kind of a judge he was.
He was calm and unflappable and kind and rigorous, and if you were counsel in front of him, you were put through the hoops, but with no aggression. There was nothing hard-edged about him. And the thing that emerged to me all the time I sat with him was that his style and his manner of conducting a court got the best out of everyone. It was irrelevant who succeeded and who didn't. The best came out of everyone who was with him, the judges with whom he sat and counsel who appeared in front of him. It was an absolute masterclass.
And so you were first then in the High Court, was it, at that point?
Yes, and I would sit with him in the Court of Appeal Criminal Division.
Was he frightening?
Whether he was frightening depended on whether you had done your work. If you hadn't, he'd find you out. But again, not aggressively, not unpleasantly.
And would he very much take a lead in making the rulings, or would he listen to what you had to say, or how did it work?
He would listen to what he could get from contributing parties. So he would really listen very attentively to counsel. And he would listen very attentively to the people with whom he was sitting. He, needless to say, concentrated on which of the two of you, if there were one, sitting with him, had the greater expertise. But he always saw the advantage of having the voice which was unfamiliar with the territory, because that was the voice that would ask the awkward questions.
The thing that was unexpected, the thing that he might not have thought of.
Igor welcomed a judge coming from a different walk of legal life who would say, I don't understand, or say, why do you do it like that? And it never irritated him. He just answered it. And I've heard him say before now, it really made me think.
Is there any particular case or cases that you recall that you did with him that were important or difficult?
I sat with him on the appeal by Angela Cannings, who had had 3 children and was accused of murder. They died one after the other. And it featured sudden infant death syndrome. And it also featured some statistics which turned out not to be reliable. So when it came to the Court of Appeal, it was a very, very big case indeed, because it had implications for the statistical basis of how things were assessed. And because there was human tragedy all over it. And there was very complicated medicine in it as well. And I have never forgotten it, nor ever will, because when we'd heard the case and were preparing to work on the judgment, he let me do a big chunk of the medical aspect of it. And I was enormously affected by that compliment, and still am.
Where would you place him in the spectrum of tough sentencing judges? Was he tough? Was he liberal? Was he in the middle? Is it possible to categorise him?
I couldn't categorise him in terms of sentencing. I could categorise him in terms of overall judicial performer, which was just straight down the middle. If by middle you mean fair, equitable and just.
And was he the sort of judge who would lie awake at night worrying about cases such as the Angela Cannings case, or not really?
I don't know whether he lay awake, but he certainly was determined that it would be pitch perfect. I'm not sure whether worry is the right word, but no stone was left unturned. Every single detail, every single sentence was thought about. He was meticulous. He knew that anything he did would be under scrutiny, but he particularly knew in that case, because of how much it was going to matter, that every single thing had to be 110%.
Can you remind us what the ruling was in that case?
She was successful in her appeal. The acquittal was overturned.
So in other words, you and he, were you sitting alone?
No.
Or one other?
He was in the middle and he had 2 of us, one each side.
Were you unanimous?
Yes.
And was it something that you struggled, or he struggled over, or was it quite apparent?
It wasn't that he struggled, or either of us with him struggled. It was that you had to go so carefully through every last thing. You couldn't just say to yourself, well, the answer here is obvious, because that way lay disaster. You had to work through all the evidence, very technical and very human in both areas, and make quite sure that the conclusion you reached was justified.
His humanity, that was one of the things people mention about him. That would have informed that case, and presumably other rulings that you did with him. Was he a very human judge, or how would you encapsulate his personal qualities?
Humanity shone out of every pore in that man's being. And it wasn't mawkish or over-sentimentalised or any of that range of words. It was quiet, humane, dignified, gentle, calm and tough.
He was very popular, wasn't he, with other judges, would you say?
He was very popular indeed, partly because he was such a dream to sit with. He was an absolute dream. If you sat with him, you felt dignified and you were part of his thinking. And also because he looked after the judges. He stood up to be counted and he rolled up his sleeves and had a go at protecting the judiciary. And he knew the importance of an independent judiciary. And in his quiet but deadly fashion, he kept saying it, so he was much adored.
And he had great sympathy with the rank and file and would go round. And of course, his background, tell me a bit about that. He came from the Midland Circuit, didn't he?
He would often describe himself as a circuit hack. I've no idea where he got that from. Circuit was correct, hack, never. But he would tell youngsters of the time he was rejected for pupillage at his first application in the first set of chambers. He liked telling that. But he had never lived an exclusively grand legal life. And he always thought that spoke a lot about him because it helped create the man he became. And therefore he did understand how life was lived. He knew all about getting up at 4 a.m. and getting out to a far-flung court on circuit. And he knew all about calming a defendant he was representing and keeping a police officer whom he was taking through the evidence under control. He had the entire set of skills, but he would always be the one to say, the fact that I was steeped in the criminal law, I came from the criminal bar, and not even the London criminal bar, the Midland Circuit, is a vast proportion of why I have emerged as I have.
He cared very much, as you say, about the morale of the judiciary, the standing of the judiciary. And is it fair to say that he elevated that standing and he raised their perception, I think, or perception of them?
I think inevitably the judiciary as a body is likely to reflect how its leader, the Lord Chief Justice or Lady Chief Justice, is seen. So to that extent, the judiciary did very well out of Igor, because you couldn't fail to warm to the man of such dignity and status and scholarly instinct. And therefore the judges did well out of that. They also did well because he was a doughty fighter for principle and he understood that he had to stand up for them. So we absorbed all that as well. Judges got a very good deal in Igor.
What were the particular passions and principles, maybe more, that really underpinned his time in office and drove him and beyond? Well, actually, when he went to the House of Lords and took up the cudgels there and was quite a leader.
The rule of law had to prevail. There was no question about it. You couldn't decide things on a difficult case basis. That way lay disaster. Rule of law. You had to articulate it and apply it. And you had to be brave too. He couldn't be doing with gesture politics. And he was very, very astute to keeping politics and the law separate from each other. He was entirely loyal to the will of Parliament. He might have disagreed with some of the things he was required to do, but he certainly understood that it was essential. He did them and would say so, and the judges took their lead from him. So he was also so articulate and so charming to listen to that his audience was quite ready to accept what he said. He had a standing start in elegance of mind and elegance of delivery.
He was a popular leader for the judiciary, and I think that was very evident, wasn't it, on the day he retired and his valedictory in his own court, when everybody by tradition stands up and they make their tributes. Yeah. And I think you were there that day. Tell me about that day.
The day of Igor's valedictory, I'll try and get through this with some degree of composure, was never to be repeated. The judges, who are important, sit on the bench facing out. There is standing room only. People are swinging from the chandeliers in court. And the rest of the judges just stand at the back of the important seated individuals. So it's a crowded house, and there are tributes, one after the other, from the well of the court. And then the outgoing Lord Chief says a few words, and he did. And this, you have to remember, is legal London. So it does a lot by respect and silence. And always, when it's finished, the important seated judges stand up as of one, and they bow, and the court bows, and they go out. And this happened. And just by coincidence, I ended up in the corridor immediately outside with Igor. And I couldn't quite believe what I was hearing, but for the first time ever, that courtroom broke into applause. I've never heard it before. I don't think I'll hear it again. And it just went on and on and on. And I said to him, Igor, stand here a moment and just listen. This day will never come again. And it's the only time in all the time I've known him, he put his head down and I couldn't see his face. And I have a shrewd suspicion of why he did it. And we just stood there.
And other than that, which is a very telling moment, his legacy in a couple of words and what you'll recall of him?
Stick to your principles. They're principles for a very good reason. Don't give in. And don't do it aggressively. Do it calmly and rationally, and you will prevail.
When he retired as Lord Chief Justice in 2013, Lord Judge became active in the House of Lords, where he was so respected and effective that in 2019 he was elected convener of the crossbenchers. His popularity was evident from the wealth of tributes to him at the time of his death from all parts of the House. Lord Hennessy, the constitutional historian, was a fellow peer and shared Lord Judge's passion for the need to guard constitutional boundaries, for parliamentary sovereignty, and for the rule of law. I spoke with Lord Hennessy on how he recalled Lord Judge's contribution.
He was one of those figures who, in his very quiet way, had talismanic qualities in the Lords. There's not very many of them, but there are people who you listen to because of their formation, the quality of their mind, and also their temperaments. They've come together with a combination of knowledge, insight, and wisdom that you want to hear on a subject before you vote. There's probably about 20 of them, and Igor was right up there at the top. And it was partly because it wasn't just the domain that he'd made his own, the law. He was a judge of proper procedure in Parliament, how the House of Lords should conduct itself, and indeed how human beings should relate to each other. I'm not of an age now where I think in terms of having mentors or heroes, but if I was still capable of having mentors or heroes, Igor would be one of them. I never had a boring conversation with him. And his special genius, and I think that's the right word, it was in the middle of one of those eternal Brexit debates which drove everybody mad. I mean, the phlegmatic British, most mature political system in the world, the moment the word Brexit's mentioned, even in the House of Lords, they go back into a kind of adventure playground for adolescents, Well, Igor was the antithesis of that. And he'd say things to me, he said it more than once, of course, compared to the eternal verities, this is not really that important, It really isn't.
He brought sanity and wisdom, and he put things in context.
Exactly.
And as you say, not just as a result of having reached the top positions in the judiciary, but because of his temperament and personality, although obviously those are connected.
That's right.
Did he become convener of the crossbenchers?
Yes, he became convener of the crossbenchers, who are kind of fruity and excitable lot in their own quiet way. But I think it was all unanimous. I think everybody wanted Igor. And he was very good at it, because he's very good at running things. I suppose if you run the judicial system, and with some very difficult people in it.
Quite. He was good at managing people.
Yes, and he as well was an antidote to the view that is generally abroad, that the crossbenchers are the political wing of the British establishment. I mean, because he was far above all that sort of stuff. You couldn't parody Igor as a toff or somebody who hadn't got there on the basis of merit or didn't know much, because he knew a lot. He was there through absolute merit, and literally he always brought something of considerable value to whatever the business was, all in that quiet voice. I remember he said to me when he first was appointed to the bench, his dad, and I think he had a very happy upbringing, if I remember, said, "You must not succumb to judge-itis." And he never did.
No, he wasn't
never did.
pompous. And I think, I don't know whether you had personal experience of this, but he was a very kind man,
Yes,
wasn't he?
he was.
And there are numerous examples of his helping people and being nice to people. And I personally remember when my father died, and he had no reason to know my father or know of him in any shape or form, but he wrote a letter, and it was about my father had been a prisoner of war in the war, and he wrote a letter saying, talking about that generation, what a brave, remarkable generation they were. But it was such a nice letter.
Yes.
And I thought, out of his busy schedule as Lord Chief Justice, that was quite remarkable.
Yes. That's why one relished his company, whatever was going on, whether it was a snatch lunch between the business, whatever, or whether he was appearing before the select committee that I was a member of, the Constitution
Yes,
Committee.
I'd like to come to that. He was a man of faith, I think, wasn't he?
I think so.
Did he ever discuss his beliefs with you, his religious beliefs?
I think we might have alluded to them rather than discussed them directly. It was James Mackay I talked to about matters of faith, because, of course, James was so interesting with his kind of Protestant background he had in Scotland.
Well, I think Lord Judge was brought up in Malta, and I think I can remember his mentioning that he said his prayers at his mother's knee kind of thing when he was a child. So I think it probably stayed with him.
Yeah, he was very interesting about his birth, because it was Malta under siege in the war, and as they were leaving the nursing home, a German bomb fell on the other side of the main entrance to the hospital from which he was being carried by his mum. And he always, when he was told this, and his dad, I think, explained it to him as well, that if the bomb had been on their side, Igor would have died after what it was a week.
Yes, yes.
And so he had a sense of the precariousness of life.
Yes, indeed. So your work, you saw him in general debates in the House of Lords, and but also specifically on the Constitution Committee, didn't you? Where he came and gave evidence.
Yes.
Now, tell me a bit about what you remember about his contribution to that committee.
Well, we were talking about the role of the Lord Chancellor and the Attorney General, but I was very keen, and so were the others, I think, on the committee, that we should get Igor and some of the others to go higher and wider than just that. So we used the inquiry as a way into much bigger, wider things. When I was preparing for his appearance, I was very struck by a phrase he'd used in a lecture at UCL in 2013, I think it was. And I thought this carried an enormous amount of freight. And this is what Igor had said. Ultimately, it is the judges who are the guardians of the rule of law. They have a particular responsibility to protect the constitutional rights of each citizen, as well as the integrity of the Constitution by which those rights exist. Without judicial independence and without respect for judicial independence, these elementary facts of our civilised community are threatened. And that carried everything. He had this, again, another gift within his gifts, was to go right to the heart of the matter and to stay there long enough to capture the key, the essence of it, even if it was only a couple of sentences, as it was there. He'd remove the clutter from it all and go straight in. And that's invaluable. I mean, if I was a law student, I would really hang around on Igor's lectures and speeches because of that, going to the heart of the matter, but also how to construct a lecture, beautifully organised. He had an immensely sensitive mind, but it was also a very, very tidy mind. So he organised the eternal verities, if I can put it that way, in such a fashion that they were easily absorbable by non-specialists. Everybody knew what that sort of thing meant when he talked about it. And it wasn't because he was pious or, how can one put it, pompous or preachy. It was just, you wanted to follow the track of his mind. And that's a great gift.
It's a gift. And he, as well as that really informed his thinking. And also he was a great believer in the sovereignty of Parliament as well. So while the judiciary were the guardians of the rule of law, so Parliament remained sovereign always.
Absolutely.
I wonder what he would have thought, do you think, about the present state we find ourselves in with, and you've just written about this recently in your latest book, about politicians that we've had in the latest administrations and a flagrant disregard, as some people have said, for the rule of law.
Well, I would be very reluctant to put thoughts into his head about what we're seeing now about Rwanda bill. I can guess what he would have felt. But what he was brilliant at, which relates to the question but coming at it another way, is Henry VIII clauses in legislation on skeletal bills with secondary legislation possibilities built into them, which were really fundamental, the sort of stuff that traditionally you have primary legislation for and you don't do through secondary legislation. And he could spot a Henry VIII clause at 50 yards in a London smog.
And
he was our early warning system. He was our Fylingdale's early warning system about incoming rockets. And he would quietly eviscerate the government before those missiles had arrived.
And there was a need for that. Because,
absolutely.
Because those clauses have increased.
The recent cabinets may have virtues, but they do not lie in this area. They have no sense, really, of the checks and balances and the human sense of restraint that those in power have got to show in a country with an unwritten constitution. A friend of mine, Clive Priestley, had a wonderful phrase, cabinet office man, now long gone, sadly, when he talked about the good chap's theory of government. And the good chap's theory of government was the key to preserving our values and our protections, because the good chaps of either sexes in Whitehall or indeed in the judiciary would know where the boundaries were instinctively. They pick it up from previous generations and they wouldn't go anywhere near those boundaries, let alone cross them. And the Johnson government in particular couldn't see a boundary without whittling on it. And Igor wouldn't have approved, did not, I'm sure, approve of that.
No.
And so it's absolutely critical to the working of our system in a country with an unwritten constitution that high crown service, and that includes the military, the judiciary, civil and home services, and the secret world, know where these boundary lines are and don't come anywhere near them, let alone cross them. And recent sets of ministers have been absolutely tone deaf on that. The narrowness of the formation of the British political class is one of the tragedies of the last 10 or 15, 20 years. And this has been part of it. And as the judiciary, given who they are, and the meritocracy that they are, as kind of an antidote to that kind of second-rate behaviour, wouldn't contemplate it and wouldn't abide it.
No.
So they've become even more, I think, behaviourally, the safeguard that Igor was talking about in that 2013 lecture at UCL.
Indeed, and I think he felt, didn't he, that the diminution of the role of the Lord Chancellor with the constitutional reforms dating back to 2005 had seen the appointments to that role. Well, I think he used it as reduced the Lord Chancellor to a second division minister.
That's right, that was very candid. And you see, it was all the more potent, a very sharp sentence like that, because it came out of a very gentle mouth.
Yes.
He had this very quiet voice. And it's a great British art, actually. Certainly it's how the House of Lords works, that you can deliver a rebuke, as it were, or a judgment of real bite, but in such a quiet way that you don't know you've been eviscerated until you're bleeding all over the floor. I mean, the Lords is better than anywhere else I've ever come across at using courtesy as a weapon. And Igor could do that. And of course, there are some ministers who are, if I can be candid, too dim to know they've been sliced up. But most of them have a slight unease. I think he said something here. Yeah. And he was the master of that.
Do you think he would have been concerned about the balance of power between the limbs of our constitution, whether it has shifted with those reforms, with the judiciary no longer having a voice in cabinet. Do you think he felt the judiciary was weakened?
I suspect he did, from the way he gave his evidence to us. You see, again, it's a crucial insight into the British Constitution that you can have a minister at the cabinet table in the person of the Lord Chancellor of the old sort, who is both head of a profession, as it were, and also a cabinet minister, and therefore with a political feel. And the most successful Lord Chancellors are those who have had both in abundance, who would always jettison the political in favour of what the judicial side showed us was the way to proceed or not to proceed. Modern politicians find it very difficult to understand that because they're so partisan compared to the old days that they cannot conceive that you can have somebody at the cabinet table who is not a political partisan as they are.
Yes, and I think he regretted that they were even given titles such as Deputy Prime Minister.
Yes,
that just made them politicians,
right.
and likewise the law officers, the Attorney General, Solicitor General, all that diminished the independence in a way, didn't it, of the justice system in his view, and maybe of your view. What do you think?
Well, absolutely. If we're talking just before the Rwanda Bill comes to the Lords, if it goes through pretty well as it is now, it will be a profound moment in the history of this country, not just the legal history, but the history with the capital H. Because when it's taken for royal assent to the King, he will have to sign away this country's place on the list of rule of law nations. And in the time it takes for the document to go back from the palace back into the Cabinet Office, the few minutes it takes, we'll have become a different country. And I don't think several ministers in this cabinet, perhaps the majority of them, have any sense of the magnitude of that, of the gravity of that, because the deeply ingrained sense of the rule of law, its salience, its indispensability, its purpose, its knock-on effects on everything else. If you haven't got a feel for that or an understanding of that, you don't know your own country. And what does that tell us about a cabinet? If they can contemplate doing this, whatever their views on the problems of mass migration, to pass legislation in Parliament for the royal assent to get us off the list of rule of law nations, do they not see we'll be a different country?
Igor would have been appalled.
We miss him. His speech in the second reading would have been the one that we all hung on. No question about that. No question. There's a kind of little game I play with myself as the years advance. Is which gang do I want to go and visit when I get into heaven, if I do get into heaven? The Valhalla containing the old LCJs and the Supreme Court justices will be early on my list. I think I'll go first to the old military to get their gossip, because they're tremendous gossips. Then perhaps one or two members of the old political class, one or two members of the university profession. But then I'll go for the judges. And the first one I want to talk to is Igor. I'll need a briefing from him about what state of mind they're in and where are the hot spots.
This podcast was brought to you by the University of Law. Subscribe now to make sure you don't miss the next episode.